All right, I'm going to now give you an overview of contract law in two slides here. Very important that you understand contract law. It's a foundation for, obviously, business, how businesses operate, interact with other businesses, and it's just critical that you understand these basics. Now, we're going to talk first about common law contracts. Now, remember, common law, those are court decisions that have accumulated over time. Think of it as a manifestation of judicial power. Now, this goes back, common law goes back to England, and so these concepts are fairly old, but they are relevant. So, for example, the four basic elements of a enforceable contract you must know. And these can save you a lot of money. I've saved clients millions of dollars by going back and analyzing contracts based on these basic four elements. So the four elements of an enforceable contract, you must know these. And not only for this course, just to be a smart business person and not get screwed over and understand when you're writing contracts how it occurs and what you need to make sure you have. First, the subject matter has to be legal. You have to have a legal deal. If you're dealing with illegal drugs or contraband, forget it. You're not going to have an enforceable contract. So, out of the box, you're knocked out. So, legality. You'll see your book talks about some cases that concern the certain things that can happen, like war, or I think it's important to understand that statutes can modify and define what's legal and what's not legal. So you have to be concerned about that as well. So statutes can, as I've discussed before, modify common law. So you have to be aware of that. So a statute can define a particular subject matter as being illegal. Capacity is the one I like to focus on because a lot of people in your textbook doesn't, I don't think does this particular element justice. Capacity, your book talks about the concept of dealing with a minor, somebody under 18, that they lack the mental capacity to know what they're doing unless it's for necessity. Or you're dealing with somebody who's drunk or high or something like that. Hopefully, in your business, you won't be dealing with those people. You might be dealing with minors, but typically, if you're dealing with a necessity, they are obligated to pay for that. Or if you're a smart business person, you'll have an adult cosign on those kinds of contracts. I look at capacity in a more practical way, and I suggest you do so as well in your business. Here's how you do it. First of all, you want to verify who you're dealing with. Always verify. This is critical. Certainly you want to trust the person or the company, but verify their existence. Make sure that they are who they say they are. Verify, that they're licensed to do business in the state with the Department of Revenue. If they claim they're a corporation, make sure they are registered as a corporation. Don't take their word for it. I've had students get screwed over by deals over the internet, whether it's like Craigslist jobs, and ends up to be a total scam. And the easiest thing to do would be to Google the website or Google the email address of the offeror to determine who you're dealing with. But you definitely have to verify. I've had cases, as I alluded to, where clients have been screwed over, and I've gone back and looked back at capacity, and lo and behold, the entity they cut a deal with didn't exist. It was a bogus entity. Always verified. And this is also apropos if you are getting sued yourself or pursued by a collection agent or something like that. Verify who they are. That's very, very important. The agreement itself is, again, only one part of an enforceable contract. A lot of people mistakenly say, well, all agreements are contracts. No. You can have an illegal deal. You can have a deal with somebody who lacks capacity. But the offer and acceptance, your book spends a lot of time on this. Under common law, the offer has to be sufficiently definite. If I hire you, we have to agree on a wage, right? If we don't agree on a wage, then and you work for me, and then we don't have we don't have what's called a meeting of the minds. a meeting of the minds. My mind didn't meet your mind. We didn't agree on the critical material elements of a common law contract. In an offer, it's important to understand that the offeror is the master of the offer. And what do I mean by that is that the person making you the offer can put whatever they want in there as long as it's legal. So if they want you to respond by, driving your bicycle 10 miles or something crazy like that, it's totally okay. This is the stage where you need to, have a complete understanding of what the deal is. And in my role as a private attorney, I often look at what's the exit strategy if there's a problem, or what's the penalty that I can put in the contract in case the other side breaches the contract. So that's the offer. The acceptance under common law has to mirror the offer. Think of a mirror. If you deviate from my offer, if I offer to sell you my car, for $10,000 or something, and you say, fine, but put on new tires, that's not an acceptance of the common law. That's a counter offer. Then you become the offeror, and then it's up to me whether to accept it or not. So you'll see that in your materials. There's eventually you'll see a comparison between what's common law contract and what's called sales law, which is a very important distinction for purposes of this class. Consideration is the final element. Consideration is basically the bargain for exchange that seals the offer and acceptance. It can be money, it can be forbearance. I offer you a job, you give up, you forbear looking for other jobs, and then the day before you're supposed to start for me, I tell you, forget it, I'm not going to hire you. Is that consideration? Yes. Yes. Normally it's money, but it can be that you gave up an opportunity. Now, in the life cycle of a contract, obviously the objective is full performance. Now, you'll see your book talks about substantial performance, which means you did just about everything, but there were some non-material things you didn't do. I hired you to build my house, but you put in the wrong trim or something like that, or the wrong carpet. Could I just walk away from the contract with you to build the house? No. There'd be an accommodation made for the deviation from the original contract, but it's not enough for me to walk away. So understand the distinction between full performance and substantial performance. Then you have breach. Now, breach, you're looking at a material breach of contract. It's got to be material. And if there is such a thing, if it happens, there are various remedies, and these goes back to our discussion of damages. What is it going to take to compensate you? What's the consequences of it? If I hire you to build a house for me, you don't get it done, or there's some fundamental problem, and I got to live somewhere for a while, that's a consequence of your failure to perform on the contract. Couple of terms you should know, which are pretty self-explanatory, but one is statute of frauds. Now let me explain what this is. And if you think about it, a lot of the legal terminology, if you just look at the words, makes sense. A statute of frauds, this is a statute. It actually goes back to common law, but it's been codified, passed by legislative bodies in statute. Statute of frauds, these are statutes to prevent fraud in certain contracts which have been historically susceptible to fraud, like sale of real property. If you take an interest in real property, if you buy property, or you're a lender and you look at real property as collateral, that's got to be in writing. So the statute of fraud simply says there are certain contracts that are so susceptible to fraud that they must be in writing to be enforceable as a contract. To be enforceable as a contract. So you'll see your book discusses these. Interest in real estate, contracts which by their terms cannot be performed within 1 year. Someone is acting as a guarantor on a contract, an agreement, that's got to be in writing. And then promises to marry and any sale of goods over $500. So statutes can require there be a writing, and we'll see there are a number of statutes that do require this. And the writing requirement can be accomplished in various ways, but that's if you don't have a writing, there are remedies, and I'll talk about this shortly. But the other thing to remember is statute of limitations. This is time limit by which you have to get off your assets and do something, sue somebody. And so there are time limits on everything, even crimes. So for our purposes, a contract, I should say, contracts can be oral or in writing unless the statute requires it to be in writing, like statute of frauds. Now, smart businesses are going to have all their contracts in writing. You're not going to do oral contracts. That's not prudent business practices. But nevertheless, it happens. And keep in mind, oral contracts are enforceable. And the statute of limitations, the time limit by which you must enforce the contract if there's a breach. So you have a certain time limit after a breach. Depends on the state. In the state of Washington, it's 6 years on a written contract, unless the contract says otherwise, and 3 years on an oral contract. So that's just something to keep in mind. And if you wait too long to enforce your contractual rights, if you sue somebody in the 7th year, the courts don't have any jurisdiction over that. So you're totally screwed. A little bit about assignment, delegation, and novation. Very important you understand the term assignment. Now, you have a contract, and the contracts have rights and duties, right? So I lend you money. I'm a bank, I lend you money. In return for me lending you money, you give me a mortgage on your property, all right? And that's the collateral that I'm looking to in case you don't pay me on the loan being the contract. If you don't pay me, I'm going to foreclose on your property, right? So I can assign the right to be paid to someone else. Assignment refers to a right, assignment of a right. Normally it's a right to be paid. Well, banks do this all the time. Just as I described, I lent you money, you give me a mortgage, a lien essentially on the property. You don't, I can sell your contract to someone else because I need money. I can sell it, and normally a mortgage, which is just a contract, certain type of contract, a loan, your note, that's the other word for it. Those are sold 20 or 30 times. And eventually, if you don't pay me, somebody's going to come out of the woodwork and say, you know, you didn't pay Professor Newman, now you owe me, and I'm going to foreclose on you. Now, again, go back to my discussion here on the 4 basic elements of an enforceable contract. Always verify capacity. And if someone is claiming they have a right, they've been assigned a right to collect, you want to verify that. And certainly if the subject matter falls within the statute of frauds, like real property, the assignment's got to be in writing as well. Now, normally you will know about an assignment because you will be paying that person rather than me, right? So you're going to be paying whoever I assign the right to. But sometimes your contract will provide that you have no right to be notified who the contract has been sold to, and you'll still be paying me, and I'll just be the agent for the owner of the debt. So, but assignment of a right, very important to understand that concept. Commercial paper operates on assignments. Delegation of a duty, this is a duty to perform. Now, there are a lot of exceptions here, like I'm hired to teach. Here, I cannot delegate that to somebody else without permission from the institution. So delegation is of a duty. Now there's this term novation. Novation comes from the Greek nova, meaning new. This is a new contract. This is a situation where there's been an assignment. And with an assignment, let me just say, there's a phrase that I think is very helpful for you to understand assignments. The person assigning, in the example I gave you, I'm the bank, I'm assigning. I'm the assignor, O-R. At the end, the suffix O-R, you'll see that used frequently in the law. O-R means one who assigns. Promisor, one who promises. Obligor, one who is obligated. O-R, kind of a useful way to understand some of the legal terminology. So in a novation, I assigned the rights to collect your home loan to somebody else. I'm the assignor, that somebody else, that third party, is the assignee. Now the assignee steps in the shoes of the assignor. Important that you understand that. The assignee steps in the shoes of the assignor. That's legal terminology, which basically means that if in the original contract some illegality or fraud, or you felt you were screwed over, the assignee tries to enforce that contract, you can sue both me and whoever is trying to enforce it and claim that, well, Mr. Newman engaged in fraud, the contract, there's some problem with the contract, the assignee inherits all that mess. So the original parties, you'll see there's a term in the book called, these are the original parties in privity. The word privity means the original parties to the contract. Then you start to move away from it with delegations and assignments. Normally, you'll see in your contracts, especially, for example, if you're renting an apartment, your rental agreement will say there will be no assignments, no subletting, etc., without the permission of the landlord, which makes sense because the landlord supposedly vetted you, determined you're a reasonable person, maybe did a credit check, understood who they were renting to. So you cannot unilaterally assign things typically without the other party's consent. Now, lastly, let me just mention this concept of third-party beneficiaries. This is the idea that when you're dealing with the other party and entering into the agreement portion of an enforceable contract, it's understood that the parties in privity, by the parties in privity, the offeror and the offeree, that there's some third party who is the intended beneficiary or the donee beneficiary. For example, let's say your parents go through a divorce, they enter into a parenting plan, you're not really part of that, but part of the deal is that your father's going to pay for your college education. That's essentially a contract. Let's say father decides not to do it for some reason. Can you sue to enforce that contract? Yes, you are a third party intended beneficiary, a donee beneficiary, to do that. Now, there are unintended beneficiaries which have no such rights, but you'll see that discussion in your book, Third-Party Beneficiaries. Just make a note of it. Now, I'm going to move on to a second part of our discussion here on contract law. And oftentimes you'll see in a contract there are conditions that are part of the deal. So, for example, you buy a home, one of the typical conditions is that you qualify for financing, if the home passed certain inspections, etc. If you live in a homeowners association or in a community that with a homeowners association, you'll have covenants. Covenants are normally in the deed itself that will limit what you can do, or the deed will refer to covenants. Very, very typical if you live in an area with a homeowners association, what you can or cannot do. Another typical clause, and when I use the word clause, I'm talking about just a written paragraph in a contract. Another clause is an exculpatory clause. Now this is, the way I remember this is these are escape clauses, basically. If you've ever gone skiing or scuba diving or been on a sports team or something, you'll see these. They basically say, hey, great, you're going to be skiing with us, but understand if you kill yourself, that's your problem. And if you sign off knowingly, it's voluntary, and you get injured, is that a defense for the company that rented you the skis? Yes, it is. Is it an absolute defense? Not really, but it depends on the circumstances. So exculpatory clauses are enforceable. A lot of people, oh, you can't do that. If there was a case years ago in Washington where a fellow died scuba diving, signed off one of these, and the agreement said, hey, realize it's highly dangerous, you could die, person died. Family sued, lost because he signed it away. Your book talks about unilateral and bilateral contracts, very simple concept. Unilateral is the idea of a promise looking for performance. I'll pay you $5,000, you drive my car to San Diego. And so I'm looking for you to perform. If you halfway through you abandon the thing, you're not going to get paid. Bilateral contracts are a promise looking for a promise. So you do have, you can have a situation where you have a unilateral mistake, where one person just doesn't understand what they're buying or selling. Those are kind of, depends on the circumstances and if the other party essentially took advantage of that error. A bilateral mistake, both parties just never, there was no meeting of the minds. They just never met. So there's nothing, there was a lack of basic understanding. One way to resolve a contract dispute, if the amount at issue isn't liquidated, and when I say liquidated, I mean a set finite amount. If it's not liquidated, if it's in dispute, you can do something called an accord in satisfaction. So let's say we have a dispute over how much I owe you, and I agree, well, you know, as an accord, I'll pay you a certain amount of money. And once I do that, that satisfies or is the consideration for the new contract. And that's essentially a way to get rid of a problem, accord and satisfaction. Make sure you know what rescission is, where I rescind the offer, and restitution obviously is where both parties, like in a bilateral mistake, they'll be restored and given their consideration back. Very common to have limitation of liability clauses, somewhat like exculpatory clauses, but you know, in contracts, especially for construction, there'll be a provision for liquidated damages where they'll talk about the parties have agreed up front, if you don't complete the job by a certain date, there'll be a per day penalty of so much money. Now there's a couple of concepts I think are very important for you to understand. One is called promissory estoppel. Now, estoppel is a word you're going to see elsewhere in the law. If you look at that word, it has in it the word stop. You see, it has S-T-O-P-P. This, think of it like this. This is where you are being stopped from reneging on your promise. You promised to pay me $5,000 if I drove your car to San Diego. I'm here, you know, I performed, you need to pay me. Now, let's say there's some weirdness where it's not an enforceable contract. Let's say, you know, I'm a minor or something like that where I can renege on the contract. Promissory estoppel I view as kind of a remedy where, for whatever reason, there's a problem with having an enforceable contract. Maybe the agreement or something, there was something weird there. It should have been in writing, let's say, and it wasn't in writing, right? Like I sell you my car, let's say, and you pay me and I don't perform. Promissory estoppel boils down to detrimental reliance. I relied to my detriment on your promise, and I'm going to go to court and ask the court to enforce the agreement, even though there may be some problem with it being an enforceable contract. That's promissory estoppel. Okay. The other one you need to know is called quasi-contract. Quasi-contract, as the term would suggest, it's not really an enforceable contract, but it has elements where you received an unjust enrichment. An unjust enrichment. Example being, I'm at my home, sitting on the porch, along come some contractors, they get out, they put a new roof on my house, new gutters, they hand me the bill, and I say, sorry, you got the wrong house, thank you for the new roof and gutters. Am I liable on that? Yes, I would be under the concept of quasi-contract because I received an unjust enrichment. Last concept I want to talk about in the area of common law contracts is parole evidence rule. Now this is the idea that you have a contract, and the contract normally will have what's called an integration clause, a clause that simply says this is a complete understanding of the parties, there's no other oral or written understanding. Now, if it has that integration clause, obviously there can't be any prior oral or written understandings that contradicts the written deal. Very good to have an integration clause in there. Even if you have it in there, the parole evidence rule says you can introduce oral or written understandings that clarify what the deal was, and certainly anything that happened after the deal. So if I buy a car, you're selling me a car, we agree that I get a stereo system. You don't define what the stereo system is, but orally you agreed to put in a high-end stereo system, and I get the car and it's got a doesn't have that in there. Can I pursue contractual remedies based on your failure to put the system in that we discussed? Yes, so long as it doesn't contradict the written deal. So that's the parole evidence rule.